Welcome everyone to the first day of our almost 4-week training class. Today we want to welcome our guest speaker, Joe Coluntino. Joe is one of our staff attorneys. He is a member of our concierge team as well. And we are happy to have him with us today. We are going to be talking about agency first, and then the second half of this afternoon we're going to be talking about lead paint. So welcome, Joe.
Thank you, Susan. So Susan and I are going to kind of collaborate going through this stuff. Obviously we're going to start with agency, go through the multiple stages of agency, how it works, what we want to do, how we want to be prepared, and understanding what your role is, what the client's role is, who you represent, where your fiduciary duties lie, and all that type of stuff. So Susan, I don't know if you want me to just jump off, or if you wanted to jump off and
No, we're on page 1 of the manual, and we're going to talk about, I did give you each a copy of the agency disclosure. We're going to talk about the different types of agency, especially when we get into buyer agency, the difference in the customer and the client.
I can seal this one.
Yes, I'll do so.
Yeah. Can I see one of those, please? Thank you.
Sorry about that.
No, it's okay.
Disclosure? Yes, I have one, thanks.
So you want me to
Sure.
Want me to start with agent?
Yep.
So what an agent is, an authorized person act on behalf of another, called a principal. The language of the real estate agent, principal, i.e. buyer, seller. So essentially we commonly know what an agent is, right? But an agent is someone that is having a fiduciary duty to a client. So you're acting as an agent on their behalf. Client, also known as the principal, is the person who we represent by an agent. The client relationship is, again, a fiduciary relationship. So fiduciary relationship, we know that we have a duty to our client that not only aligns with their goals, but with all the laws surrounding that. So we want to make sure that they're, as a consumer, fully informed of their rights, who we are. We want to make sure that they're very clear that we represent them, that they are the principal to us, and that what we're doing moving forward is in their best interest on their behalf. And obviously we're not going to make unilateral decisions, so we're always going to be consulting with our clients, with the principals, and then acting on their behalf as the professional. Then into designated agency, individual agency. So as a designated agent, designated to be an agent for a buyer or seller, to the exclusion of all other agents in the brokerage real estate firm. Another salesperson in the firm could be designated agent for the other party without thereby creating a dual agency for the individual agents. Susan, I don't know if you want to elaborate on.
When you look at our form that I handed out, we have it checked off that we are a designated company. That means that you and only you represent the agent. So make sure that you understand that when you're filling out the form. When I hand these out to the client that I'm working with, I always say this is not a contract. This is a statement, and it's exactly what Joe just said. This is a statement of representation. So you have to explain to them that you're either representing them as a seller's agent or as a buyer agent, and again, whether we are a designated company or not.
And what that basically lends itself to, and it goes into, is when you're getting a client, whether it be buyer or seller, and they do fill out the disclosure, you want to really make them understand that you are representing them. It's not LAER as a whole. It's not Jane Smith can pop in and out for you. It's that you are their representative. And then if you do come upon those dual agency situations where you're simultaneously representing both buyer and seller, we need to really make sure that everyone is informed and we get the informed consent of both parties that understand you're representing them both, and that lends itself for a layperson to think, okay, conflict of interest could be here. So that's kind of, as an attorney, where I always tell people, make sure that both sides are represented by an attorney, and your role as a dual agent is not going to have to be clouded at any point, because they will have independent professionals on the other side to hash out things that could arise as a conflict later on down the road.
So I have questions.
Yeah.
So would you suggest presenting the explanation of dual agency at a listing appointment so that the seller understands that ahead of time?
I think if you're pretty confident that you're going to get a buyer in there without an agent, I think it's something it's not going to hurt to educate your clients. It may help you get a listing when you go in there and you're the only one that really explained what dual agency is. I think a lot of lay people, like the thing that I'll always hear from people that are not in the real estate industry, well, I'm not going to have a buyer's agent because that means they'll take more, they'll take my offer. And so I think that's probably a stigmatism with a lot of people, that they think agents are kind of out to do this every single time, is get this dual agency representation, which isn't necessarily the case. I speak to many LAER agents that say, I'll never do dual agency, I just don't want to. I'll rather refer it off to someone and have them represent a buyer or a seller. I don't want to do it. Which is fine, you don't have to do it. But if you do, you have a specific form that informs everyone of what dual agency is, and it's very easily accomplishable. I think on a listing agreement it would be a good thing to go over, hey, in the case that a buyer walks through here without an agent, I could represent them. You'll fully be informed that I represent them, and as will the buyer. The buyer will know that I'm duly authorized as an agent to represent them both in this transaction. Just a quick story for the weary. I did have a deal before where the agent did not explain dual agency properly. It was signed. When it got to me, I said, oh, and I explained dual agency. The seller flipped out. Now we have a signed offer, and we have signed dual agency form that she wasn't informed very well on, and it became a very big problem. It ended up to be to the fact where an agent had to be assigned to the buyer because the seller was so weary of dual agency. So it was something that we were able to handle, but obviously the front end of it, the real estate brokers and agents really need to help people understand what they're getting into.
I think the understanding of the scripts are important. We're going to go over the dual agency in more detail on page 4. Can you talk a little bit about Facilitator, which we're really not using that much, are we?
Yeah, facilitators, I think you get into more facilitative roles when not so much in residential type of real estate transactions. Otherwise, you're just going to list it as a salesperson. You're not going to jump into something as a facilitator. Maybe for a family member or a friend, you would use that role. But you're still going to be bound by the same fiduciary relationships. You're still going to be bound by the same ethical standards that you are as a salesperson. So if you're ever faced with a facilitator type role, you're going to use the same judgment and the same rationale that you would if you were getting a standard commission.
Can you just touch on that a little bit more so I understand it completely?
On the facilitator form? Yeah, so So a facilitator would be, I'm just trying to think of a real life situation where a facilitator kind of comes into play. It would be, I know of a listing, I know of a buyer that listing would be perfect for. I'm going to connect the two parties and I'm going to ask for money. I'm going to connect those two parties. I'm not going to draw up an offer. I'm not going to have any standard fiduciary duties to either of those, but just realize consumers, what they think is much different than what you think. So when you're a facilitator, you want to make it abundantly clear, hey, I'm a facilitator. I don't have any of your fiduciary duties really at the forefront here. I'm just connecting you two. You guys work it out. You make the deal. I just want my 2%, when you guys close. But I'm not doing anything else. I'm just here to connect you two. You guys do the rest. So that's real world, practice of how a facilitator would work. So yeah, it could come up, but more than likely that seller that you got will be a lead where you convert that into a listing. So now you're actually working as a listing agent, and vice versa. The buyer could be a buyer lead. It's uncommon to get in those situations. That's why I say it's more common in commercial applications where you're working for a property owner that has multiple warehouse spaces, and they say, go find me a warehouse. You find that warehouse, you get that seller. The seller says, I'm not listing it. If you bring me someone, we'll think about it. And all you're doing is connecting parties. So that's more of a traditional facilitator type of a role.
Thank you. So on page 2, it talks about when you're represented, when do you need to present the agency disclosure? And it says in here, at the first personal meeting to discuss specific property with a prospective buyer or seller. Of course, we like to encourage people to meet at the office rather than just meeting them at the house, but it's important to have that agency disclosure signed.
And obviously that is a struggle, right? Because how many leads do we get off of Zillow, real-time type of leads where you're meeting at a house to let them in, to show them, and then this kind of muddies those waters when you're like, here you go, nice to meet you, can you sign this? So to Susan's point, if you can get people to come to the office and meet with them first before you go out on a listing, before you go out on a listing appointment, that's when you can kind of bring this stuff up. Hey, as a consumer, I just want to let you know, this is disclosing to you that I would be acting if you decided to put any offers in on these properties as your principal. It's not a contract, and you go into your pitch at that point. But again, there are very strict rules with all of these documents that have to be met. We'll get into lead and the strictness to that as well. So.
And this is why I use the script to explain to them up front that they need to know who you're representing. That say, I'm representing you as the buyer agent, or I'm representing you as the seller agent. It's not a contract, it's a statement of fact. So that kind of makes it easier for them to sign it. They're not signing a contract, they're just signing a declaration of how they're being represented.
And there is a box to it. I don't know if anyone's ever come to this. If they don't want to sign it, you just check the box. They decline to sign. So it's just good habit. This is the first form you need to get signed in any transaction. And if they don't want to sign it, they don't have to. Some people are very wary of signing things, which is understandable. They think it's a contract. It's not. It's a disclosure, and it's there for consumer protection because people. We've all probably seen it. I've definitely seen where consumers are taken advantage of from an agent that is just thinking about their wallet rather than doing the right thing. So it's a law for a reason. Following it's the best way to not get in trouble.
Some of the questions that are asked here are who can sign the form or who must sign the form. So if you're going out with 2 people to look at a house, have you run into problems with that where only one person signed it? Or?
I've never run into a problem, but I've definitely had deals where a wife or a husband only has signed it. And best practice is to have everyone that is going to be a principal of you sign this form. So just think about signing a purchase and sale, but one party doesn't sign. It's not a complete contract binding that party. So it's best practice again to any consumer that is going to be making a decision to buy or sell this home should be signing this form.
That's a good way to put it, because it could be a grandmother and a grandson buying it together. Whoever the parties are that are involved should sign it. Also, it says the broker must retain the disclosure for 3 years, so we're very good about keeping all of the records.
Bless you.
This next one is interesting about the open house exception. Can you talk about that?
The real estate licensee must conspicuously post and or provide with other written materials any relationship so that attendees can understand the relationship that may be the licensee conducting that open house. So essentially what that means is you could put this form out and say that this is a designated agency. You could put it in a listing package that's, again, open on the table in plain view so that they can see it.
And we also have a form that you can get from your admins that when you're doing a listing of, you're the listing agent, that it states that you are representing the seller. I forget what the exact wording of that is, but you could also have someone else from the office covering your open house, and that's a whole different scenario.
Yeah, so in those situations, they are not an agent for the seller because it's designated, right? So in those situations, if you're covering for an open house, maybe you have your own separate form that you just put out, and then that lets buyers know, and I'm not the list agent, I have no fiduciary duty to the seller. Happy to speak with you if you wanted to put in an offer. We would have a consent form signed that I represent you only and not the seller. So you can explain it to people. It's a good way to build rapport with people. It's not something that you should shy away from because you're afraid that people will get scared off from this. I think it's more of a relationship builder because they realize, oh, this person has my back. They have my best interest at heart. So.
Some of the terms that you're going to see a little further, but we should mention the explanation of them now. For instance, fiduciary, which Joe has mentioned many times, talks about relationship.
Yep, so a fiduciary is a relationship that implies position, trust, or confidence wherein the person is usually entrusted to hold, manage property, money for another. It's a faithful relationship, so that's the best way to put it, right? So your client is going to have faith that you have their best interest at heart, and that if they tell you something in confidence, that it's not going to get out. They're also going to expect that you're going to tell them, you know, your opinion and thoughts, and that you're not going to give those opinions and thoughts to someone else. So you're going to keep them to yourself after you give them to your client. And again, that's something that a fiduciary would do. So as an attorney, every relationship that I have with a client is a fiduciary relationship. I have to, and that's kind of known. So if you think of it as the age-old, everyone knows attorney-client relationship, as a fiduciary, it's essentially the same thing. So you're a fiduciary for a buyer or a seller, and that relationship is faithful. You're going to know intimate information that would harm your client if you would ever let it out. So, and the next one is informed consent. So informed consent is essentially it's written consent. So they're fully aware, fully informed of what they're doing, and that's why we have all these forms that lay out relationships, what's going on with the deal, and you have your clients sign, and as well as other sides sign sometimes, so that all parties are on the same page. Everyone knows I work for the buyer only, I work for the seller only. Here's our signature, and it's memorialized in the transaction forever, especially the way that LAER has .loop set up and things like that. Anyone can log on and see what the relationship was. Anything you want to add to that?
The vicarious liability?
Yep. So vicarious liability is something I'll hit upon later too with the lead stuff. As an agent, you can be vicariously liable for actions of your principal and vice versa. So you can do something that could put your client on the hook for a lawsuit, and as well as they could do something that puts you on the hook for a lawsuit. So vicarious liability is basically being held liable for others' actions, and when we form this type of relationship, that is a very real fear. So we want to make sure anytime we're having someone, even on a dual agency form, if we're filling this out, we want to make sure that, you know, a lot of this stuff is electronic nowadays, so you want to make sure that everyone understands it's in their handwriting if it's handwritten. You don't want to just be kind of going through the motions, because if you do something wrong here, translates into them not understanding you were working for them. They put in, they tell the buyer something, let's say you represent a seller, they tell the buyer something that you had no knowledge about. You move forward business as usual, after closing, a lawsuit happens, you get looped right in. So something to think about. Anything you want to add on that, or?
No, but if anybody has any questions as we're going along, feel free to. Now we're going to talk about the duties required of licensees.
Do you want to go over this one? I don't
Sure.
know this acronym. I don't.
So this is old car. These are the all of the important things that we should remember: obedience, loyalty, disclosure, confidentiality, accountability, reasonable care. So obedience is an agent must carry out all lawful instructions of a client. So you're representing them, and that's you're doing what they tell you within law, obviously. Loyalty, an agent must act in the best interest of a client. Disclosure, the agent must disclose all information relevant to the client. Confidentiality, which is very important, is the duty to keep confidential the client's information or discussion. Duty survives termination of client relationship. That's important as well. Duty does not apply to legally required disclosures such as known physical hazardous conditions of the property. Does everyone understand what that means? Accountability. Agent must protect and account for all money, documents, and other personal property given to her by the client. Reasonable care and due diligence. The agent must act competently, capable of performing duties within the scope of the license requirements. These are the foundations of acting properly under the agency that you're representing. So let's go on and talk about types of agency, some of which we're really not even doing anymore, such as sub-agency. But in the seller agency, the real estate agent represents the seller as a client and treats the buyer as a customer. The agent's duties to the seller client include old car. Okay? Are we even discussing sub-agency?
I mean, sub-agency does come into play a little bit. I think some of the higher end properties where agents would enlist the duties of other agents, maybe in that marketplace, to help bring some of their clients through. So sub-agency, again, most common way that you would see it, let's just use the higher end property as an example. Very hard property to sell type of thing. The more hands on deck, the better. And you would say to your client, hey, I'm going to bring Susan in on this one. Susan is really good in this market. She understands her strength is the marketing aspect. My strength is the contract aspect. We're going to essentially team up if needed, if we can get the agents in. So essentially, Susan is now an additional agent of the seller, a sub-agent. All the same standard of care applies. So as a sub-agent, you're really thinking on the same lines as a seller agent. With going back to informed consent, you want to make sure that everyone understands your role as a sub-agent, that there's no blurry lines, that all of a sudden you don't jump over to a buyer and use all the information, intimate information that you've gotten from the seller against them. So those type of things apply. If you do end up becoming the buy side, you're going to want to get dual agency forms signed and things like that, and vice versa. So same thing with sub-agents on the buyer side. Very similar, way less common. So I don't think it's even useful to get into. I think sub-agency on the sell side is most likely.
And with buyer agency, the real estate agent represents the buyer as a client in a real estate transaction. An agent's duties to the buyer include old car. So just old car is the foundation of your business, and always to be remembered. Let's get into dual agency a little bit more and try to understand the examples of that. A real estate licensee who represents both the seller and buyer in the same transaction is a disclosed dual agent with written informed consent of both the buyer and the seller, see below, which we'll go into. Fiduciary duties are owed to both the buyer and seller. Undisclosed dual agency is illegal. A dual agent assists the seller and buyer in the transaction, but shall be neutral with regard to any conflicting interest of stand-alone consent form. If consent is obtained prior to the identification of a transaction, then a notice of dual agency must be provided. That's interesting. So if it's before they've actually zeroed in on something that they're going to buy. Duties of disclosed dual agency include only car of old car. So go back and look at that again. The car of old car was care, accountability, and confidentiality, sorry, accountability and reasonable care and due diligence. Written consent form must state, and we have all of these forms in Dotloop, a real estate broker or salesperson may act as a dual agent who represents both prospective buyer and seller with their informed written consent. A dual agent is authorized to assist a buyer and seller in a transaction, but shall be neutral with regard to any conflicting interest of the buyer and seller. Consequently, a dual agent will not have the ability to satisfy fully the duties of loyalty, full disclosure, and reasonable care, and obedience to lawful instructions, but will still owe a duty of confidentiality of material information and the duty to account for funds.
So back to the original point, into dual agency. The more knowledge, the better. So you don't want to be the real estate agent in my example, that the attorney says, oh great, dual agency, and have your client flip out. So you want them to be fully informed, consent to everything, and if you need to draw up something in addition to the dual agency consent form, you can do it. I mean, it's pretty simple. So knowledge, give them more knowledge than needed, make sure they understand what you're doing. And I've seen a lot of agents that are successful at this set this up in the beginning. If it becomes a dual agency, this is what, obviously I can't be loyal to you or to them. I can't be obedient to you or to them, so that's why obviously the obedience and the loyalty come out of that, that acronym. So there's still a standard of care. You have to be confidential. You can't go back to one. So you have to act in the best interest of both of these people while facilitating this deal. So you can't use knowledge against one another. You can help, essentially, if you think of it as a mediator, you can help get the two parties together and agree on things that make them both happy. And that's the role of dual agency. Again, getting attorneys involved at the outset is not going to hurt you. It's going to alleviate a lot of liability on your end. So that's another thing to think about.
Buyers and sellers should understand that material information received from either client that is confidential may not be disclosed by a dual agent except if the disclosure is expressly authorized, required by law, is intended to prevent illegal conduct, or is necessary to prosecute a claim against a person represented or defended in a claim. Oh, that's all legal jargon. You're on for that.
Yeah, so let's just work through it, right? And I like to just use examples as the easiest way for me to explain things. I think if you guys don't like it, let me know. Expressly authorized, seller says to you, tell the buyer, I would accept $250,000 if they take away that inspection contingency. You're expressly authorized to go tell them those exact terms. So obviously you can go and tell them, I would take $250 if. That's my line of thinking. If required by law, obviously if let's say you know that there's a certificate of lead, just to get back to lead. If you know there's a lead certificate and the seller's telling them, no, don't give that to them, don't give that to them. You have to give that to them. So you're required by law to do something, you have to do it. If intended to prevent illegal conduct, so that would be some kind of fraud. So if you're helping the seller cover something up, a latent defect in the property, or something that could turn into, I'm just trying to think of a real life scenario of illegal conduct. It would probably be if the seller is planning on stealing a deposit, you have to disclose the other side. The seller's planning on never selling you this house, and they're just doing this to steal your deposit. That would be a very off chance, but that would be something that's illegal. They can't get into a binding contract just to take a deposit. And if necessary, to prosecute a claim against a person. So what that is, so in the legal profession, if we ever get sued, we can use confidential information to defend ourselves. Same situation here. So if you're being sued by a buyer or a seller, you can use the confidential information that you have to defend yourself. So that would be a real world scenario of that.
So the next page of your manual, again, it says the duty of confidentiality shall continue after termination of the brokerage relationship, and that's very important to remember. The notice form must provide when consent to a dual agency has been given by a seller or a prospective purchaser in advance of the identification of potential transaction. Written notice of the dual agency must also be given by the broker or salesperson to the seller and prospective purchaser after a transaction has been identified, stating that the broker is a dual agent with regard to the transaction. Written notice of dual agency shall satisfy section 13B herein, and such written notice shall be given prior to the seller and prospective purchaser entering into a written agreement. So again, it's exactly what Joe is saying, that everyone needs to be informed and understand before it actually happens.
And the rationale, pretty simple behind that. If both sides understand your role when building an offer, the offer will reflect that understanding. So the seller has given the agent a lot of information pre-listing before even meeting this buyer. The buyer has now given the agent a lot of information pre-offer, their wants, their needs, where they're at, their financial information. So it needs to be understood, hey, I know a lot about the seller, I know a lot about you. This is my role right now, is to get your offer presented to the seller, and I will have both of you, both of your, I will be an agent for the both of you separately, but in this transaction, mutually, your mutual interests will all be at stake here. So the real risk is if you were to get into an offer situation where it wasn't disclosed properly, and that offer then turned out to go a little south and deposits were at risk, well, now the agent not disclosing dual agency properly puts you on the hook for liability to a consumer, which in these scenarios, we have what's called Chapter 93A here in Massachusetts, which is consumer protection laws, and you open yourself up to treble damages, so 3 times the amount of the damages is what you could be liable for. So you want to make sure when we're representing consumers that we're understanding and fully disclosing to consumers. You have to think, a consumer comes in, they don't know anything. Even if they're a real estate agent, they don't know anything. Disclose, 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 and then you always have something to go back to and say, I told Susan on May 1st that I was representing the seller, her as dual agency. These were my specific duties of care, and I followed all of them. So as long as you follow those, you're fine.
So the consent forms must be kept for a minimum of 3 years. The process for dual agency should always be disclosure, consent, and notice, if applicable. So important things to remember there. The next 2 sections talk about the fact that we are a designated company and the specific things that are are points to being a designated seller and or a designated buyer. So the designated seller's agent will represent the seller and will owe the seller the duties of loyalty, full disclosure, confidentiality, access of funds, reasonable care, and obedience to lawful instruction. All other licensees affiliated with the appointing broker will not represent the seller, nor will they owe the other duties specified in that paragraph. If designated agencies affiliated with the same broker represent the seller and buyer in a transaction, the appointing broker shall be a dual agent and neutral as to any conflicting interests, but will continue to owe the seller and buyer the duties of confidentiality. Gee, that's a good one. You want to comment on that, Joe?
So, let me just pick up. So, obviously the difference here is because the brokerage is designated, let's say Susan has a listing, I'm also an agent at LAER, I have no duty of loyalty or any duty of care to Susan's clients. If Susan's telling me things about her client to ask me questions, there is a little bit of a gray area there. Obviously she can ask colleagues specific questions. I would then kind of get carried over into that confidentiality, but those are the type of things that you would have in perpetuity, this confidentiality to your client. But for a few instances where she can be asking professional advice from another professional and not disclosing maybe the full extent of names and things like that, but the whole scenario. So other than that, you need to keep the confidential information confident throughout. That could affect, the knowledge we have could affect someone's ability to buy or purchase or sell in the future. So we need to make sure that we remember that.
In the same aspect, the designated buyer's agent will represent the buyer and will owe the buyer the duties of loyalty, full disclosure, confidentiality, accounting of funds, reasonable care, and obedience to lawful instruction. All other licensees affiliated with the appointing broker will not represent the buyer, nor will they have the other duties specified. So I think that's understood. The next section, the policy and legal issues for designated agent practice. I thought this would be a good one for you, Joe.
Yeah, so to touch on what Susan just said about within LAER, right? So let's say that someone represents a seller, someone represents a buyer, both LAER agents. The broker of record cannot take a side on whoever's wrong or right. So if a conflict ever did arise between LAER agents and a brokerage, just realize that the broker cannot, not if one party's broker of record, which I believe is Stacy, may not be, but the broker of record cannot take a side. They have to stay neutral throughout. So that would be an outside resolution. So any resolution to that would either be handled by outside attorneys or through a court of competent jurisdiction that has no affiliation between
board arbitration or
exactly.
something like that.
Yep. It would be neutral to LAER. So it wouldn't be Stacy couldn't say, "You're right. Give the deposit." We have to stay neutral and let that go outside of the walls of LAER. Just to add to that.
Interesting. When using common area computers, always close out and delete personal files. Never leave files and paperwork. I actually saw this recently where someone left an offer just laying around in the common area. And you just always have to be careful for your own sake and for your client's sake to keep everything. If you've printed out a document on the printer, get it quickly. Don't let other people see, because there could be 2 or 3 agents in the same office putting an offer in on the same piece of property. So that's really important. When discussing real estate transactions by phone, make sure you are in a private area. Again, you just need to be really careful about conflicts of interest. We just talked about that a little bit, if there are conflicts.
Yeah, and I think conflicts are pretty standard. I mean, it's common sense. When you think someone is going to be relying on things you're saying, and they rely on those things that you either put in writing or you say, and it adversely affects them, and they're adverse to your position, there's going to be a conflict of interest. So back to that scenario where two agents, same company, there's definitely a conflict of interest because you both work for the same company. So that would want to go to a neutral third party to make a decision on that.
So going on to the next page where the form is again, a lot of this will be automatically filled out in dot loop, but our brokerage license number, which is 8890, is usually right in there. You need to fill in your license number. If you're doing this in dot loop, it's really simple to do. Whenever you put your signature in, if you're doing it in dot loop, the date comes in automatically. If you're signing this by hand, they can put their signature in, then print it, and then put today's date, and then you're going to upload this into dot loop, obviously. On page 9, we actually talk a little bit about New Hampshire, which I think that we should do because we have a lot of great agents and a lot of us who are licensed in New Hampshire as well. And the New Hampshire agency form is quite different. And Joe is licensed in New Hampshire as well.
So in New Hampshire, I'm not a New Hampshire attorney, but I am a title agency in New Hampshire, so it's a little different. I'm not a,
different.
Yeah,
Yes.
it's a title state. We know if anyone does New Hampshire deals, we know we go right to purchase and sale, so the role of the attorney has kind of been taken out of the equation. Obviously, attorneys can be used from the outset, but the offer is essentially the purchase and sale, so you get right into the nuts and bolts of the agreement. The broker relationship, it's again very similar to Massachusetts, what they're doing. They're disclosing what the different types of agencies are, the relationships, and then having everyone that's a consumer, again, fill it out and disclose exactly what it is.
And it says, I acknowledge receipt of this disclosure. So again, the importance of it is explaining what they're signing.
Yep.
And the second page, of course, tells all about that. But they're acknowledging the fact that you have explained it, and that's why they're signing it.
And I would say to everyone that's going to do New Hampshire, or even everyone that's going to do Mass, know these forms inside and out. You want to sit down at a listing agreement, and whether it be buyer or seller, and be able to go to page 3 and say, who's the client? Circle it and say, you're going to be my client because of X, Y, Z. We have a fiduciary duty, and go over it. When I do a real estate closing, I have a packet this big. I'm not going to explain every page. I know every page, so when I see the page, I can easily go, on this page, it's all about taxes. So this is authorizing the bank to get your tax form for years, blank, blank, blank. I know the forms inside and out, so I tell everyone, if you're going to have 4 or 5 different forms that need to be checked off a box, lead paint, consumer agency disclosure forms, know them inside and out. They're not hard, they're 2 pages. Read them, and then when you get an agent, you can say on here, I'm going to be buyer's agent. This is buyer's agent X. You want to read this paragraph right here. These other things don't apply, but if you want to read them, you can. This is really where you should hone in right here, buyer agent. And then we're going to sign that. That makes people understand this isn't a contract. They're just disclosing what they are, what our relationship is. And the same thing, this just is a little more in depth about the roles and things like that, but it's essentially the same form.
Right. If you turn to page 13, this is the form for consent to dual agency. Which is what we just went over.
Yep.
And again, like we've said with everything else, the acknowledgement of it is them having had it explained and them acknowledging that they understand what has been explained.
And everything, this form is a very short version of everything you could put in there. You can always add addendum to things you have people signing. So you can have this form, and then you can have an attachment right to it, laying out your specific role, and you could even put in there what you're going to be providing, what services you're going to be providing. It's not legal in any manner. It's not a contract. This is the form you want, but then you can also have, if things ever go south, another form that says, I told the buyer and the seller, and they both signed, and it's pretty explicit what my role is. So we're always thinking, obviously I think a little differently as an attorney, we're thinking what's going to go wrong and how to avoid it. So that's essentially my 2 cents kind of. on when you do a dual agency, you want to get this form, obviously, but you can feel free to add to it with a little short addendum. And that addendum is going to apply forever, so you only have to draft it one time, and then you got it forever.
Anybody have any questions on agency? It's a lot to understand. There's a lot of different roles that you can play. If you have difficulty understanding it or explaining it, you can always ask me or Stacy or Joe anytime with any questions. We're going to switch gears now and go into lead paint, which I think will cause a lot more questions and have a lot more stories. I got up and I didn't.
And just to add too, and I tell every LAER agent that I meet with, I like to think of myself as like legal tech support. So any questions that come up, even if I'm not going to be the attorney on a transaction, don't feel as though you can't reach out to me. It may be a simple, hey Joe, quick question. I can answer it very quickly. Phone call, text, email, whatever it may be. Happy to help everyone to make sure that if it's something you can learn from, great. You become a better agent because of it, great. If it helps you not get in trouble, even better. So I'm happy to answer any questions, no matter how you may think it's a minuscule question or an embarrassing question. You think you should know it. Don't worry, I'm not going to judge anybody, and I'll just answer it.
That's really helpful, thank you. As we lead into this section of lead paint, we're going to watch Stacy's video first, and then we will talk about the lead paint form. And this video can be found in the Career Den, in the library. Oh, it can be found in the library under the LAER University, but I think also on the left-hand side you can go directly to LAER University. And this is one of the modules almost to the bottom of the page, and it's called Lead Paint 101. And this is Stacy speaking about the importance of understanding and filling out your lead paint form properly.
Thank you for joining me today for Lead Paint 101, what you need to know to protect your clients and avoid fines on real estate sales or purchases. Overriding policy of the lead paint law is to encourage full disclosure of all lead paint related issues, and it conspires the opportunity to test for lead paint before they purchase a home with lead paint. Unlike rental properties, however, there is no obligation on the seller to actually de-lead prior to a private sale. But common sense dictates that a lead-free house may be more valuable and marketable, and this is particularly true for multifamily properties where tenants with children under 6 years of age may in any event trigger the de-lead requirements of the law. Sellers and real estate agents that do not meet the requirements of the lead paint law can face a civil penalty of up to $1,000 under state law in Mass, and a civil penalty of up to $10,000 and possible criminal sanctions under federal law for each violation. In addition, a real estate agent who does not meet requirements may be liable under the Massachusetts Consumer Protection Act, which provides up to triple damages. By the way, under federal law, the penalty also includes the loss of a real estate license. Who needs to sign? Whenever an owner of a home built before 1978 sells, the listing agent must provide, number one, a property transfer notification certification, and number two, all 10 pages of the Department of Public Health Childhood Lead Poisoning Prevention CLPP property transfer notification disclosure. Most agents only use 1 page of the form, and that is a no-no. You must provide all 10 pages of the Childhood Lead Poisoning Prevention Program. By the way, most of what we're covering today is for a purchase or sale of real estate. The law also applies to rentals, and for rentals, there is a specific version of the property transfer notification certification and the Childhood Lead Poisoning Prevention Program form. So whether it is a rental or a purchase, if a home is built before 1978, the form must be signed by all parties. Can the buyer sign a lead paint first? No, it is invalid. The property transfer notification certification must be completed and signed by the seller before the buyer can sign it. The buyer's signature acknowledges that they are in receipt of the disclosure. Thus, the buyer cannot be in receipt of the disclosure until the seller first completes the form. So when you are first meeting a client as a buyer's agent, it's a great idea to still give the 10-page CLPP form to your buyer so they understand the lead law, because what the lead law says is if there's a child under 6 living in the property, that by law they're supposed to de-lead it if they're buying the property. So it's a good idea to give that 10-page form to your buyer at your first or initial consultations, but you should not have the certification signed by your buyer until there is a property they're buying and the seller has filled out the form first. What has to be filled out? All disclosures and acknowledgements have to be accurately completed, including the seller's disclosure, the purchaser or lessee purchaser's acknowledgement, and the agent's acknowledgement. Agents should be aware that HUD and the EPA have audited brokers' files in the past and have at times found them deficient from a compliance standpoint. Thus, it is absolutely critical to accurately fill out the form. Make sure that the property transfer form, the signature page, has at the bottom of the page a request for the property address, a line for the property address. If it does not, you are using an outdated version of the form. Does lead paint need to be signed if the house is built in 1978 or later? No. The lead paint law only applies to homes built before 1978. Therefore, testing for lead-based paint is not required. If the listing agent provides a property transfer form for a home built on or after 1978, neither the buyer nor the buyer's agent has to sign the form. Can we refuse to let a buyer test for lead paint? No. A property owner or real estate agent cannot sidestep the lead paint law by refusing to sell or rent to families with young children. The purpose of the lead paint law is to protect the health of children and pregnant women. An owner cannot refuse to sell or refuse to renew the lease of a pregnant woman or a family with young children just because a property may contain lead hazards and they do not want to spend the money to remove. Any of these acts is a violation of the lead law, the Consumer Protection Act, and various Massachusetts anti-discrimination statutes that can have serious penalties for property owners of real estate or real estate agents. Now, that is not to say that your seller would be required to de-lead a property. The issue that comes up here is that any potential buyer has an absolute right under federal and state law to perform lead paint tests prior to becoming obligated under a sales contract. But can the seller legally instruct the listing agent to inform all potential buyers to waive this right or they'll reject an offer? No, because any instructions along these lines would potentially give rise to a fair housing violation for discriminatory practices against families with children under the age of 6 and lead to liability on behalf of both the seller and listing broker for participating in discriminatory behavior. The issue that arises is that we cannot decline an offer simply because somebody is asked to test a property for lead paint. That being said, if the lead paint testing does take place, number one, at that point, your seller may now have knowledge that the property has lead paint, and also the lead paint tester may report it to the state, in which case that the seller may have to fix the lead paint issues if they continue to own the property. Let's say that the buyer requests to do a lead paint test and it is determined that the property has lead paint. That does not mean that the seller must do all the repairs for the buyer. Just like any other item that a buyer may request, any work done on a property or painting or replacement of anything, the seller can decline to do the work. They are not required to sell the property de-leaded, but they cannot decline an offer simply because a buyer has requested to do the lead paint test. When should the lead paint transfer notification be signed? Although Massachusetts law states that the completed property transfer lead paint notification form must be acknowledged by all parties prior to the signing of the purchase and sales agreement, the notification form must actually be signed by both parties prior to the acceptance of any offer. In instances where an offer to purchase residential real estate is utilized because that offer is a binding contract for the sale of the property, and the purchase and sale agreement is simply a reiteration of the terms of the offer with other terms and conditions for performance thereunder. The law allows the buyer 10 days in which to have a lead inspection performed. If lead is discovered, the buyer may withdraw from the sales transaction. So in essence, that lead paint form needs to be completed prior to the offer. This is what that 10-page form looks like. If built before 1978, buyers, sellers, renters should get all 10 pages of the property transfer notification. This is that Childhood Lead Poisoning Prevention Program property transfer lead paint notification, that CLPP, the 10 pages before that come before that signature page. This 10 pages should be given to every buyer and seller for properties built prior to 1978. Again, if you are working with a buyer, you should never have the buyer sign the actual certification until you have it filled out by the seller. But I think it's a great idea to always give the 10 pages, the 10-page form to your buyer well in advance of buying a property so they understand what the law is if they end up buying a property that was built before 1978. Here's the actual property transfer notification. We're going to break it down into segments to make sure you're getting these filled out correctly by your buyers and sellers. The first section is just the required federal lead warning statement. It lets people know that this form needs to be signed by the prospective purchaser before signing a purchase and sale agreement or a memorandum of agreement, or by the lessee prospective purchaser before signing the lease with an option to purchase for residential property built before 1978 or for compliance with federal and Massachusetts lead-based paint disclosure requirements. Please note that New Hampshire has its own version, but very similar, same form. New Hampshire has its own version as well. If you're working with a landlord tenant, there is a third version of that, of the property transfer notification certification. It then goes on to explain the warning. It says every purchaser of any interest in residential property in which a residential dwelling was built before 1978 is notified that such property may present exposure to lead from lead-based paint that may place young children at risk of developing lead poisoning. Lead poisoning in young children may produce permanent neurological damage, including learning disabilities, reduced intelligence quotient, behavioral problems, and impaired memory. Lead poisoning also poses a particular risk to pregnant women. The seller of any interest in residential real property is required to provide the buyer with any information on lead-based paint hazards from risk assessments or inspections in the seller's possession and notify the buyer of any known lead-based paint hazards. A risk assessment or inspection for a possible lead-based paint hazards is recommended prior to purchase. The next section of the form is the seller's disclosure. Again, the seller must always complete the form before the buyer can complete the form. Warning here, always remember that there needs to be a box checked off in section A and a box checked off in section B at all times. One of the boxes in A and one of the boxes in B must always be checked off by the seller. It is not either A or B. It is always A and B, and there are multiple options under A and B, but always one box in A and one box in B must always be checked off. Too often, sellers will check off the no knowledge. They have no knowledge of lead-based paint under section A, but then they don't check off anything in section B, which is not correct. All sellers need to complete the form. Next, the purchaser section. Let's dissect the purchaser section to make sure that your buyers are initialing and checking off all the right areas. Please note that either C or D must always be initialed. So on every form, either C or D must always be initialed, not checked off by your buyer. Also, E must always be initialed. This is the disclosure, it says the buyer has received the property transfer lead paint notification. That must always be initialed. F must always be initialed. So C or D must always be initialed. E must always be initialed. F must always be initialed. Then let's go down to F1 or 2. F1 or F2 must always be initialed. Too often, agents are checking off F1 or F2, but they're not having the entire top section completely initialed by their buyers. And remember, all buyers. So just like under all sellers, if you have 3 sellers, then all 3 sellers need to check off and sign the form. If you have 3 buyers, all 3 buyers must initial, must sign, and must check off the boxes. Next section is agent acknowledgement. All agents involved in the transaction must initial, not check this section. So if, as a buyer agent, you receive the lead paint notification from the listing agent and there are pieces not correctly filled out from the seller's side, you should be kicking the form back to the listing agent saying it's not properly filled out. I'm trying to protect your seller, my buyer, and our real estate licenses. We need to have it properly filled out by the seller. Then all agents involved in the transaction must initial, not check off, the agent acknowledgement section. Next is the signature section. All buyers and all sellers, all agents must sign and date the form. Last, I mentioned this earlier, at the bottom of the form, it's going to ask for a property address. Make sure the property address is filled out completely. And if your form is not asking for the address, then you are working off of an outdated form. Thank you for joining me today, and thank you for protecting your buyers, sellers, renters, landlords, and our brokerage and your license by making sure your lead paints are properly completed. Thanks for joining me.
Amazing, right?
So that was the first time I heard that because I couldn't open it on my computer for some reason.
Oh.
But it was really good. So Stacy hit on all of the major points, and I think she emphasized the things that really needed to be emphasized. Has anyone ever read this form, like cover to cover? So it's something I think refreshing is never bad. Like reread it. I think it changed in 17 a little bit. So just, whenever you have a second, reread the thing. Listing appointments, again, from a lawyer perspective, if you put this into dot loop and you put where the seller is going to initial, just from conversations you've had with the seller, that could easily turn on you later if there were lead or they did have lead documentation, but you just put no, and then forwarded that along. So when you have both your sellers in a room, have them hand fill that thing out. Hand fill it out, explain it to them, make sure they're doing it right. You'll have it in their handwriting. I mean, that's just my own personal preference and opinion.
So let's start at the top with the seller's disclosure. And Stacy did a great job with explanation, but let's talk about it a little bit more. If you're representing the seller and you're meeting with the seller to sign the listing documents, you're going to ask him the questions. These questions apply a little bit more if you have a multifamily, as far as the notices, but in the first part, in A, he's either going to know that he has reports and things or he doesn't. In a single family house, a lot of times they'll say no knowledge. Now, knowledge could mean that he didn't have any reports done or that he's never had it tested himself. That's
the way this law is written too, and I think we all know it, it rewards no knowledge. So the less knowledge you have, the better it is for you. So we're essentially rewarding sellers for not knowing and not doing their due diligence. However, I think that's going to change because the way the law is now, because if one reads the lead and they have a child under the age of 6, when they buy, it's on them within 90 days to get this place tested and remediate. And I'm sorry if I'm jumping off topic. What's coming in my head.
Go for it.
And I think from my own conversations with buyers and sellers, Deleaded is the big word, right? That's not really true. So it's more of remediation. It's in compliance. So we need to make sure that an inspector goes in there and tests, a wall that's painted but has lead paint underneath the paint is not so much going to be ripped out. It's going to be encapsulated. So that means the house still has lead. It's not de-leaded. Still lead under this paint. Mm. Windows, doors, door handles, baseboards, things that can get hit with a vacuum, can easily chip. Windows are going up and down all the time. Those are the things that inspectors come in and say, yeah, you got to take out the windows, you got to take out the baseboard, or encapsulate the baseboard. You got to take those doors out. Those doorknobs have lead paint. You got to take those out. So that's remediation. 4 feet up, basically not too many 6-year-olds higher than 4 feet. 6 feet up needs to be encapsulated and not lead free, but with inside of the legal parameters that lead can be present. So a lot of times the reason I say that is because you don't want to be using these terms accidentally. It's lead free, because that's a very hard thing to fill. Lead free is very difficult. All these old buildings in Boston, it was just built, it's lead free. Don't ever get hung up on writing lead free. In compliance, if you can try to use that type of terminology, it's in lead compliance, not lead free. It's in the lead compliance.
So a couple of things about that. If the seller says that he has had a 2-family de-leaded, get those documents from him and have him initial that properly. But also have him check it, not initial it. Have the forms posted in your paperclip in MLS so that they're there at the beginning. Because you need to prove that if he said it's de-leaded, was it really de-leaded? I have a question. We're going to talk in a minute about tenant-landlord lead paint law. But I had a question come up recently from an agent. If they rent to somebody, just a husband and wife, and then
have a
become
kid
pregnant after the fact.
Mm-hmm. Yeah, so if they then ask for a risk assessment, you have to do it. Mm. So if they say to you as a landlord, we just had a baby, we want this place checked, you have to do it. And if there's lead, you have to remediate it. So the duty is on you once they essentially ask you to do it. You're never going to find a set in stone answer on that, because that's a very common fear. But just because your tenant has a child doesn't click something over. If you're going to ever re-rent it, you have to. You can't rent. So you can't, obviously, I don't know if you want to jump into landlord tenant yet, but I can touch on that stuff after. I think it's important to.
Yeah, it's coming.
Yeah. We'll get to that more.
We'll talk about that in a minute. Another thing about this is when you post in MLS, you've got to post the 10 pages. If you're doing it through .loop, the 10 pages are there. Yes, this is the signature page, but when you go to take this form that's signed in .loop and post it to MLS, the entire document has to be signed, not just the signature page. If you're showing a house, I love the part, I gotta remember that 500 times on the blackboard. You should have the lead paint signed before you do the offer, because an offer is a legal contract in Massachusetts. So if you're showing a house and you look in MLS and the paperclip does not have a lead paint form, you're gonna call the listing agent and say, can you forward the lead paint form to me so that my people can sign it? So that this can be part of our offer package that we send over. Does everybody understand that?
Yeah, the state is taking this obviously very seriously. $1,000 fine from the state, plus you're also open up to 93A again, because these are consumers, so it's your duty to tell them that about lead paint. Very easy to do. You give them a package and tell them to initial it. But I think reading it as an agent helps you understand it better. It will help you present it better to your clients. And it also will help you explain to a seller, like, hey, this is the law. You don't need to so much do anything if there's lead paint, but if you have any reports, let's have them, and we'll give them to all buyers. And I think
if you have any buyers with children under 6, you need to just advise them, hey, when you're doing your home inspection, it's a little more money. I'd call a lead inspector because it will be on you to remediate this lead once you buy within 90 days. So, sorry.
Oh, I have a good one.
Yeah.
What about lead in water? I just had one.
Lead in the water and the pipes. Yeah, I think that's so. Malden's one of those towns that.
Buckington.
Yeah, Malden's one of those towns that they make you they scope your water line to make sure that it's the lead-free connection to the house.
Yeah.
So I believe a traditional lead inspector would test the water and all those things, but it could be.
So not getting off topic, but explaining a little bit, when you're writing an offer and you explain to them that they have a 10-day period to test, testing can be whatever they want it to be. And, you know, you can have a regular home inspector, but you can also have a lead inspector come in, and you can test lead in the house, you can test lead in the water. So there are other things besides your general home inspector that can be tested and done by different experts in their fields.
Yeah, and just so you know, it's not a reason for the seller to have to renegotiate. It's not like, oh, there's lead, because the seller has no duty to remediate this problem unless they have a child under 6 and they're buying. So it really falls on the buyer. The buyer can make a decision, upon inspections, it's gonna cost us more than $5,000 to do these repairs. It's a grounds to get out of the contract, 100%. But you gotta do it within your inspection. Just make it concurrently with your inspection window. You don't have to say, we're gonna take the 10 days, we're gonna get it tested. What's the big deal? We have the right to do that and do it. If they have kids over 10 years old, unless they plan on having a child anytime soon, it may be a moot point for a lot of people. They may just want to get it tested for their own knowledge.
I was thinking more about what you've been saying all day about explaining and acknowledging. When you look at the agent's acknowledgement part, you're going to get to the point, if you haven't already, of having these scripts secondhand. But the first one, G, says the agent has informed the seller of his obligations under federal and state law. So if you're the listing agent, you're putting your initials there saying that you've gone over this and explained how the seller should fill this out. But on H, what I would say if I was a buyer agent and they were acknowledging what the seller had said, I would say no matter what the seller has said, you still have a right as part of your 10-day home inspection to have the lead paint tested, and then you're initialing that. So depending on who you're representing, and your script is going to be different again, but they always, no matter what the seller has stated or declared, they can still have it tested if they want to.
And I thought it was in this form that I read it, but lead paint poisoning is the leading cause of developmental delays in U.S., which is pretty crazy. So that's obviously why this is so serious.
The unfortunate thing that happens a lot, and I know this will get Joe off on a tangent, is that if we have the knowledge and understanding because we're taking this course, we might explain this to a seller, but the seller might be in denial that he's going to accept because he doesn't understand the law, even especially if he's a landlord of a multifamily. He may say, I'm not doing this or that, and that's a tough position to put you in. If he refuses to do the right thing, I actually knew of an agent recently who walked away from a transaction because she just couldn't get him to understand what was the law.
Yeah, and so the landlord-tenant portion of it is a lot more difficult because you have a landlord that will say, I haven't de-leaded the place, I don't want you to even show it to people that have kids under 6. Well, we have to show it to everybody that wants to see the place, no matter age, sex, color, familial size. Otherwise we get into fair housing type of situation. Yeah. So if someone wants to see your property, you have to show it. If someone wants to put an application in, you have to give them an application. You don't have to accept their application. There's a number of legal reasons to deny someone an application to rent a house, and that's what you'd have to have a landlord do. If they want to then discriminate, you have to remember, we get back to vicarious liability. You're an agent for this principal, and things that they do may come back to you. So you got to be careful when doing anything on their behalf, especially when as it applies to lead paint, because, you know, as landlords, we're afraid, oh no, a kid under 6 is moving into the house. It's going to cost me $20,000 to de-lead that place. And, you know, it's going to cost you a lot more if you discriminate against them. So you have to be, you know, you have to be fair and careful. And, you know, if you want to deny people for valid reasons, you can absolutely do that within the law.
Well, with that, let's go to page 28, which talks about the tenant lead law notification.
So it's really the same, I mean, it's the same disclosures for tenants, but you're having them sign it prior to entering any lease. And that's the big thing about lead too, is you really want to get that thing signed. You have to get it legally signed before you sign a purchase and sale. So if you guys use .loop, it's the easiest way to have a system of, where's my lead? Oh, my lead isn't signed. You send, if it's not signed, you send the lead, and then you send the purchase and sale. So you want to make sure you sign them before. I get a lot of agents, hey Joe, we overlooked it. We never got a lead signed. Can you send the lead? I'm like, yeah. Number one, it has nothing to do with me. Like, this is your specific role. I have lead signed at closing, but they're totally different than what you guys are having signed. So that's a scary thing. And the big case on this, the case law on it is, agent was selling their own property. Buyer was represented by them, like essentially. Dual agency, it goes into both of these things we've talked about. And they forgot to sign the lead paint, sent it either after, it was definitely after purchase and sale they sent it, said, oh, don't worry, just formality, sign. Buyer signs it, never does a risk assessment. Their child then gets lead poisoning, and they sue everybody. They sue the brokerage, they sue the broker, the real estate agent, essentially the seller too, the real estate agent. But it's very important to do things in the proper way, otherwise you're opening yourself up to liability. So it's an easy step to overlook. If you get a system down, it's an easy step to not mess up on. Just get it signed.
So going back to the offer, when you do the 10-day home inspection contingency, you're explaining to the buyer, you have a right to have these things tested. That's, you are there as the trusted advisor to help them have an understanding of what their protections are. Well, and that was a real shame. Going back to, a lot of times you will see listings in MLS that do not have the lead paint in that paperclip. But, call the agent or email them or whatever and say, can you please send over the lead paint form? And in that also, because we have a compliance department, we have our admins in our offices all know how to check the lead paint form. If the lead paint, if you're representing the buyer and the lead paint form is coming from another office and it's not filled out properly, we can send it back and say, sorry, this has to be filled out more completely before my buyers will sign it.
Yeah, I think you do it in a non-facetious type way. You just say, our brokerage is very specific on these forms and we just want to make sure it's right. Do you mind? I apologize, type of thing, and just get it done right.
We had an example if you go into Career Den in the discussions, this was a while ago, but it's a good question that came up. A buyer was writing an offer on a for sale by owner on the weekend. So I'll open this up to the room. I may have said it to some of you already. So she represented the buyer. She needed a lead paint. And she wrote on the discussion, what do I do? What would you do? How would you handle that? So you have to present the blank lead paint form to the seller. This is an owner who's selling the house himself, but he has given you permission to bring him an offer. So you're handing him the lead paint form and said, will you please fill this out and sign it? Because what is the buyer doing? the buyer is acknowledging what the seller has said.
Yeah, and it's a duty of the seller to give this form. So obviously, a layperson seller is not going to understand they have to give a lead paint. So as a professional in this business, we know, hey, Mr. Seller, Mrs. Seller, here's a lead form. Read it thoroughly. Give us the information. I'm going to have the buyer sign this as well. Keep us all in compliance. Keep us all right. So that was something that I think Susan advised on. It was the right way to do it, for sure.
If you look on page 28, it explains all the parts of the lead law notifications. If you have a client that's asking you questions about lead paint, you're not the expert in lead paint. So, either advise them to have that tested, or you might give them some recommendations of a place to call, or they just say, Google a local place that takes care of that. We do have home inspectors coming, I think next week, that can speak about that as well. The other thing is about the 1978 thing.
Yeah.
Even though that's the drop dead date, there was still lead paint used after that.
So here's what the rationale was. So in the early 1900s, everything was lead paint. Lead was the silicone that you used in the windows. Lead was what we made the pipes not leak with. Lead was like the filler, and then lead also bound all the paint. So everything in the early 1900s was lead. In the 50s, I think they phased out, because I've asked this question, like, why 78, the drop dead date? In the 50s is really when regulations started to come in, and I think the US banned lead paint in like 1970. So they gave an 8-year window for builders to stop using and get rid of all their old lead materials. And, a house built December 31st, 1977 needs to get tested, but a house built January 1, 78 doesn't. So you're right, there's definitely some stuff there, but really it was a 20-year swing of when they really said, like, no more lead. I think Europe outlawed lead like recently, and Susan was talking about a newer home where a lead inspector goes into, and I just rehabbed everything, and they test something and found that there's lead because it came over from Europe.
It was the trim in the tile work in the master bathroom had lead in it. Only place in the entire house. And the trim had come from Italy.
Italians.
On page 30, I was going to ask Joe the question, but I think it's here. And I will give you another good example. There is a state agency that you can check if houses have been
De-leaded, or we'll say de-leaded because that's the terminology, but again, try to stay away from saying that word because you could put yourself into hot water.
So I had a listing in Carlisle a couple years ago, and they had lived in the home 30 years, but they bought the home at foreclosure. I'll simplify the story. The buyer agent did his due diligence and checked this registry of the state and found out that the bank that owned the house before my clients bought it had found lead and had done some de-leading work. Well, my sellers had not done anything wrong because they were never given that knowledge. So when they filled out the lead paint form, they had filled it out correctly. But because the buyer agent had found this in the state registry, wherever it is, they then had the house tested, and there was some lead, and we took care of it and all that. But that was a hard one because the current sellers had no knowledge of what had happened before they owned it.
Yeah, that's interesting.
Nor had they had it tested when they bought it.
To think of no actual knowledge. May be different than public record knowledge. So, yeah. But I think the main, I really think Stacy's video was great. If you guys go just rewatch that thing, it was really good. It hit upon, the big risks. Obviously, Massachusetts, $1,000 fine with inside of 93A, you can also be, treble damages. So God forbid a kid of 5 years old goes in there, gets lead poisoning. Now that kid can never work. That might be $1 million lawsuit. So that's pretty scary to think about. Along with losing your license, $10,000 fine just for not providing the form, and also in the federal level, criminal. There's criminal charges that could be brought for not providing this form. And then when to do it, always do it before purchase and sale. So build this into your system of before your buyers sign, purchase and sale, just make sure, did I get that lead signed? If you didn't, hey, you're gonna sign this before. I know it's kind of crazy, but if you wanna discuss it, let me know. It's 11 pages, read through it. I think it's more important if you know that this specific client has a child under 6 or is going to soon thereafter have a child under 6, explain it to them. Children under 6 can be neurologically affected by lead. It's really pretty serious. You have the right to get it inspected. It's a little costly, but if you want to do it, you get it inspected while we're doing our other inspections. They'll tell you exactly what needs to be remediated to bring this to a compliance level. And then you can even touch on true de-leading is very hard to do. It's something that, it just needs to be in compliance, which means 4 feet up, surfaces that can easily become, make dust or chips and stuff like that. Needs to be remediated.
So on page 31 is the tenant certification form. So again, if you're listing a multifamily,
Put it in.
Any lead paint certificates that you have are invaluable, and obviously the right thing to have as a paperclip on MLS. But this form should definitely be filled out before the lease is signed. What other issues or examples have you found with the?
Yeah, I mean the biggest one is tenant having the baby.
Yeah.
That's the most common.
Yeah.
It's funny, I talked about this with a guy last week or 2 weeks ago, and essentially if there is, you put them up in a hotel and you go in and get the property up to compliance.
It is the landlord's responsibility.
Landlord's responsibility. It's a moral responsibility. I mean, it's a very serious issue that comes up. So anytime, let's say we represent a buyer that's buying a multi, have them pay the money before they buy it to see if this thing has lead, if it doesn't have certs already. You can do it per unit, common areas and per unit. You can have kind of segregated lead certificates in multis too. It doesn't mean the whole building.
Oh, you
Sometimes
can.
it's.
I was going to ask that. So, if I am presuming that you guys have all read Stacy's book, The 7 Secrets, and one of the chapters in there, she talks about pre-inspection, and I was actually thinking of that with the lead paint.
So, to get way off topic, but let's just talk about inspection periods. The things I have seen the most come back and bite buyers in the butt. Sewage pipes, lead paint, and roof stuff. So those are the 3 things that like a home inspector doesn't typically come in, and some will go up on the roof, but typically they're not really like looking at the roof. They'll tell you, oh, it's old. They never scope the main drain that all the waste, and they don't test for lead. So those are the 3 areas that I always try to tell people. I know it's crazy, costs more money, but if you really want to advise your buyer clients properly, make sure you tell them, hey, you can get the pipe scoped. Think about that. And those are things that you want to talk to the seller about, because you don't want to just go in and scope a pipe and break something. But lead paint is definitely one that's maybe $350 for a lead inspector to come in there. It's not going to break the bank. And you do it concurrently with your regular home inspection.
I just totally lost
Did that screw you up? Waste pipes. Now you're going to be thinking about storage.
Well, I know that also that home inspectors now are limited to, they will say this when we have the home inspector come, they're limited to what they can, what they will do. And that's why you need to know to tell them that they can have another lead paint person to come in to test water as well. You know, if they think that's something that they want tested.
Yeah, that's bigger in like areas that have well and septic to water portability.
What I wanted to ask is this. Now that you've mentioned that, this goes back to what we talked about in the beginning about agency and disclosure. And I'm kind of getting ahead of us in all of our things, but if you do the testing, then the obligation to disclose. If you do a pre-home inspection, you do a pre-lead inspection.
Mm-hmm. Yeah, I think once you have actual knowledge of something, you have to disclose it, because you have a duty of care. If and we're talking in dual agency situations, you do have a duty to disclose it. If it's lead, you have a duty because it's here. You're not going to lie on the lead form saying you have no knowledge of lead or no certificates when you in fact do. So we're not lying. We're giving what we have. I think if you do a pre-inspection and you are not a dual rep, you have no duty to disclose anything that a buyer should reasonably find upon their own inspection. That you don't have to disclose.
I think though also that in the multifamilies, the having the de-leaded certificate certainly is an assurance, and I would think would add value to the house. I would certainly, not that I would steer, but I would prefer showing multifamilies with the de-leading certificate, because my goodness, it makes their whole world easier for them going into the life of being a landlord.
Susan,
Yes.
on the D-LEDs, I don't they have to be under 10 years old?
That's what I was saying to you earlier. So when someone has a lead certificate and it's over, even if it's over 5 years old, I would advise people get a fresh one. You already know where it is. The inspector will take that certificate, use that old certificate to kind of test places, and that's where things
So
like
it's really just an updating, not a full...
yeah, it's not a very expensive thing to get a test done.
But do you see, again, this is...
To remediate it is where the expense comes in, because
Yeah.
you have to have a professional that knows how to handle lead-based products, not make it airborne, all that crazy stuff.
And this is where, again, sometimes you become the educator of the seller. He just may not be up to date, and I hate to say it, but tenants in Massachusetts are more up to date on the tenant-landlord law than some of the landlords are. On another time, you all know that we had to go through the rental classes. If you look in the articles in Career Den, I wrote an article that was all of my notes, 6 pages of notes from the rental class that we took, and it was darn scary. What the landlord should understand, and it's all the laws, tenant landlord, are very serious in Massachusetts. And so many, I shouldn't say so many, some of the owners just are not knowledgeable about this. Why, I have no idea, but it's an uphill battle for you as the agent to have to explain all of that.
For sure, yeah, and we have to do, as agents, you have to do the right thing. And that typically involves advising your client that they're doing the wrong thing. And I get a lot of calls, on landlord-tenant matters that involve, hey, I want to kick this person out. And my first question is always, did you take security deposit? Yeah. Did you pay them the interest? No. Okay. You're already digging a hole for yourself. So we want to make sure that we're not the person digging that hole, but we're advising them, hey, you've already started to dig one here. Let's make sure you do this the right way. So the best way to do it from Jump Street with a new tenant, obviously lead form is huge. And then in your lease, you make sure that they understand you work for the seller. It's the same type of thing as a sale. You're disclosing relationship, getting them to sign that lead. If you have lead certificates, you make sure that they're up to date. And if not, you get a new lead inspector in there to give you a certificate. You reasonably know you're going to pass, so it's not as nerve-wracking as having an inspector come in and then telling you there's 40 items that need to be taken care of. So things like that.
So you're protecting yourself and you're protecting your seller. You know, to get all of that in place as you list the house prevents you from the problems down the road in the transaction.
Any questions? Any general questions?
I have one. Kind of goes back a couple of pages in here, but it was based specifically on something I had a question on years ago, and you just sort of brought it back up. It's representing a buyer, and we're looking at a FSBO, and the lead paint form was not filled out. And the seller asked me to help them fill out the lead form. And at the time I did it. It wasn't that big a deal to me. But with the language you just used a few minutes ago as the relationship between me as representing the buyer and this being a FSBO who has no legal representation whatsoever, where does that leave me if this were to ever happen in the future? To do that, or what maybe possibly should be a response to that, filling out a disclosure form, a dual agency, anything pertaining to that might be of interest to me. And the second one was, I've come across this, I can't even tell you how many times, with even seasoned realtors, the difference between a check and an initial on this form. And that, I've had this come across right here, even in this own community with seasoned realtors. And I just thought that was kind of an interesting thing, that there were so many times that it's come across me that something that was supposed to be initialed was checked, or something that was supposed to be checked was initialed. And what's the legal ramifications?
Yeah, I mean, you want it to be initialed. I mean, this form, I always like to think of we're sitting in court and we're trying to defend ourselves. What do we want? So to answer your first question, what do you want? You want to have as much documentation showing that you explicitly told these people, I don't represent you in any way. This is a lead form. You're filling it out on your own accord and giving it to me. I'm basing all of my knowledge on this off of you. That could be a text, that could be an email, that could be whatever you want it to be, but something that shows that you, as the agent, said, as a seller in Massachusetts, you have to provide the buyer with a lead form. Here is the lead form. You should read it. I can't really advise you on any of it, and please send it back to me. If you have any questions, I'm happy to answer them. That's really all I think. In a scenario of where that goes south, you've covered yourself with enough, evidence that you could bring in and say, I didn't fill that form out. They filled it out. I helped them with questions they had about what is on number F. I helped them figure that out, where they needed to initial or not initial, and I did so with the buyers as well. And then back to the second portion of that, which was, what was the second portion?
The difference between the check.
Oh, the check and the initial. So again, back to the check and the initial, which is 100% want this thing initialed. If it's checked, I would say to another agent, hey, I know it sounds crazy, do you mind just sending in that for an initial? Because it says to initial. I don't want to ever be in that position where we have to say that the seller did not initial that and that you did. Because realistically, that the listing agent could have checked that, right?
Yeah.
Sent it, and then said, Bill, initial on F, and they just initial. And that's why I kind of preface it with, don't send it through dot loop. If you can avoid it, don't. When you're at your listing appointment or when you're at something face-to-face, because unless you never meet the seller, it's a different story, but I'm sure you're going to sit down with the seller at some point in this transaction. You want to have them do it in their own writing. That's
They're all waiting. And remember what I said, we have a compliance department. You're not the bad guy. Blame it on our company. I mean, it's the right thing to do, but say we have to have this form filled out properly for compliance.
Yeah.
And say, I'm sorry
I
to
see
have to send
checks
this back, but it's incorrect.
just as much as I see initials on these. But again, for me, if it's if I'm representing let's say I have the buy side, I would bring it up and say I very rarely see the lead form, unless they send it to me with the offer, but a lot of times I don't see it. So if I see a lead that's grossly off, I would mention something, but I mean it's a very easy form to mess up, which is, it's really easy form, but how many times do you see 1 and 2 both initialed? You're like, well, you got to have one or the other. Which one is it? Did you waive it or did you have 10 days? So it's important to just follow the instructions on there, and then God forbid you ever wind up in court, you can say I did everything right. I did it all right. They waived it. I advised them. They read it. I'm not supposed to sit here and read every page with them. I'm supposed to provide it to them, and I did. So
We do have some agents in our company that have them initial every single page of the 10
can
pages.
do that too.
Yeah. Did you have questions? Oh, okay. Anybody else? Questions?
Yeah, I just wanted to ask you about the scoping of the sewer pipes. I haven't run across
To
that.
get off topic.
I haven't run across that before. I was just wondering.
You haven't run across someone asking to do it?
No.
Or you haven't come across an issue with it after?
I've come across an issue with it on
After
my
the
own
fact.
property.
Yeah. So I've had it in a handful of properties. It's not like everyone's doing it,
Yeah.
but I've had a lot of, surprisingly, I've had a lot of issues post-closing with properties that have been vacant for, let's say, 3 months. And the minute that someone goes in there and takes a shower and flushes the toilet, the water backs up. And they get it scoped and a pipe is collapsed. And that's a $6,000 expense that a new homeowner wasn't accounting for. So I just tell people that's one of those, home inspector's never gonna check it unless they can clearly see where your cast iron's coming down, that it's really corroded and they mention it. If otherwise, they're not gonna mention, hey, you know, under this cement basement floor is a cast iron pipe that goes 100 feet to the front of the house and then out to the sewer. You might wanna get that scoped.
They send a camera down or something?
They send a little camera down, yeah. They send a little camera down and they see if there's tree roots, if it's collapsed, if it's really scaled, then they can tell you, oh, the life of that thing is, you're good. Because it's encapsulated in cement, so it can be good for a very long time. But I've had a couple where people have scoped it and it was, you know, really scaly, and they just asked, you know, this was recommended for it to be cleaned out. Do you mind doing that?
Or something.
Yeah, exactly. Yeah. So it's one of my fears. I usually tell people like things that have blown up on me. That's one of them. I've had that one blow up post closing, and I had to deal with it. So I'm usually the one.
It's not much fun.
No, it's not.
But I think you can run into a lot of those with multifamilies.
Definitely. Yeah, I've had it on my place. It happened to me.
Yeah.
Thank God it was just scale, that because it had not been used for over a year.
Right, yeah.
It was vacant
No, I
for a
had
year,
one.
and then I bought it, and then the minute I had a tenant move in,
Yeah.
I go in the basement and it's like Home Alone. There's water up to the stairs, and I said, "Oh, great!
Yeah.
This is gonna be fun."
I know I had a call with City of Worcester late one night because it was a bank-owned property, and that's what happened. The pipe outside was blocked and it was coming in. It was
Yep.
horrible,
Yeah.
honestly.
Yeah. Yeah. If those pipes are pitched just a
Yeah.
degree less than they should be because of soil settling, it just comes right back in.
Yeah.
So.
Well, thank you very much, Joe.
Yep,
That
thank you,
was
guys.
great explanation. A million things for us to keep in mind every single day, from old car to how we're representing people, to making sure that we explain to them, and it's us understanding the scripts so that you have them in your mind when you're talking to the agents, so that they don't come back to you when they're meeting with Joe and say, that was never explained to me. You never want that to happen. So thank you very much
Yep.
for being here.
Thank
We
you, guys.
appreciate it.
Thank you.